Okay, this is going to be 9 minutes at 2:40. 9 minutes at 2:40. Jury charge. Ready. In order to have a fair and lawful trial, there are rules that all jurors must follow. A basic rule is that jurors must decide the case only on the evidence presented in the courtroom. You must not communicate with anyone, including friends and family members, about this case and the people and places involved or your jury service. You must not disclose your thoughts about this case or ask for advice on how to decide this case. I want to stress that this rule means that you must not use electronic devices or computers to communicate about this case, including tweeting, texting, blogging, emailing, posting information on a website or chat room, or any other means at all. Do not send or accept any messages to or from anyone about this case or your jury service. You must not do any research or look up any words, names, maps, or anything else that might have anything to do with this case. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people or places involved in this case. This applies whether you are in a courthouse, at home, or anywhere else. All of us are depending on you to follow these rules so that there will be a fair and lawful resolution to this case. Unlike questions that you may be allowed to ask in court, which will be answered in court in the presence of the judge and the parties, if you investigate, research, or make inquiries on your own outside of the courtroom, the trial judge has no way to assure that they are proper and relevant to the case. The parties likewise have no opportunity to dispute the accuracy of what you find or to provide rebuttal evidence to it. This is contrary to our judicial system, which assures every party has the right to ask questions about and rebut the evidence being considered against it, and to present argument with respect to that evidence. Non-court inquiries and investigations unfairly and improperly prevent the parties from having that opportunity our judicial system promises. If you become aware of any violation of these instructions or any other instruction I give you in this case, you must tell me by giving a note to the bailiff. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You will be provided with a notepad and pen for your use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them when we reconvene. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used solely as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Many of you have cell phones, computers, and other electronic devices. Even though you have not yet been selected as a juror, there are some strict rules that you must follow about using your cell phones, electronic devices, and computers. You must not use any device to search the internet or find out anything related to any case in the courthouse. Between now and then, when you have been discharged from jury duty by the judge, you must not provide or receive any information about your jury service to anyone, including friends, co-workers, and family members. You may tell those who need to know where you are that you have been called for jury duty. If you are picked for a jury, you may tell people that you have been picked for a jury and how long the case may take. However, you must not give anyone any information about the case itself or the people involved in the case. You must also warn people not to try to say anything to you or write to you about your jury service or the case. This includes face-to-face, phone, or communication by computer. In this age of electronic communication, I want to stress that you must not use electronic devices or computers to talk about this case, including tweeting, texting, blogging, emailing, posting information on a website or chat room, or any other means at all. Do not send or accept any messages, including email and text messages, about your jury service. You must not disclose your thoughts about the jury service or ask for advice on how to decide the case. The evidence you are about to receive concerning evidence or of other crimes, wrongs, or acts allegedly committed by the defendant will be considered by you for the limited purpose of providing the absence of mistake or accident on the part of the defendant, and you shall consider it only as it relates to that issue. However, the defendant is not on trial for a crime, wrong, or act that is not included in the indictment. The evidence that you are about to receive, that defendant has been convicted of a crime, should be considered by you only in weighing the credibility of his testimony and not for any other purpose. You are about to hear recorded conversations. These recorded conversations are proper evidence, and you may consider them just as any other evidence. You are also being furnished transcripts of the recorded conversations. These recordings are evidence, and the transcripts are provided to you only as a guide to help you follow as you listen to the recordings. The transcripts are not evidence of what was actually said or who said it. If you notice any difference between what you hear on the recording and what you read in the transcripts, you must rely on what you hear, not what you read. Both the state and the defendants have now rested their case. The attorneys will now present their final arguments. Please remember that what the attorney says is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken. In just a few moments, you will be taken to the jury room by the plaintiff. The first thing you should do is elect a foreperson. The foreperson presides over your deliberations like the chairperson of a meeting. It is the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict in the case. The foreperson will bring the verdict back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside of the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff before the respondent may be confined to a secure facility as a sexually violent predator. Your verdict must be unanimous. That is, all of you must agree on the same verdict. The verdict must be the verdict of each juror as well as the jury as a whole. If the verdict is not unanimous, but a majority of the jury determines that the respondent is a sexually violent predator, the case may be retired before another jury. Retried before another jury. If 3 or more jurors determine that the respondent is not proven to be a sexually violent predator, he will not be confined to a secure facility as a sexually violent predator, and the case will not be retried before another jury. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. During the trial, you will be permitted to ask questions of witnesses in case you missed something, you did not understand something, or you need to clarify a pertinent issue. The rules of evidence apply regardless of whether a question is asked by the attorneys, by me, or by you. Therefore, there may be a legal reason why I will not ask your question. If I do not ask your question, you must not hold it against any of the parties, and you must not discuss it with the other jurors, and please do not take it personally. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and the evidence in the case? Give as applicable. 6. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7. Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8. Did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? 9. Has the witness been convicted of a misdemeanor involving dishonesty? 10. Does the witness have a general reputation for dishonesty? It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his testimony. You may rely upon your own conclusion about a witness. A juror may believe or disbelieve all or any part of the evidence of the testimony of any witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him to be an expert. Like other witnesses, you may believe or disbelieve all or any part of the expert's testimony. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case.